As people are dialing in into our first meeting of the legal work group, I will take the opportunity to share our antitrust policy notice. We show this at the beginning of every meeting in the Linux Foundation, and it is intended to help guide people to the full policy on our website if they want to check out the rules that we use for collaboration. If you're from a Linux Foundation member company, you can ask questions of our counsel, Andy up to Grove. And naturally, if you have any general questions, you're very welcome to bring them to the table today as well. So the purpose of this meeting is very simple. We have for a long time talked about how it would be useful to have model provisions to help people include our standards for license compliance and security assurance into their discussions with suppliers and customers. Some people want model provisions to help them brainstorm around procurement contracts. Some people want model provisions to help them structure internal policy and so on and so forth. The goal of our discussion is not to create prescriptive contract language. The goal of our discussion is not to include model provisions into our standards themselves. The goal of our discussion is to find a way to have useful reference material that will support the market requirements for people to have something to brainstorm around. Maybe they'll use it internally, maybe they'll share it with their colleagues for education. It simply doesn't matter. The important thing is that we want to have support for these model provisions to give people good examples of how to include our standards in what they do. Now, to get the conversation started, and this is where we're very fortunate to have some people on the call, like Andrew Katz, we're going to have a look at some model provisions that happened in the past. You see, this conversation we're having today in this community on this topic is actually a conversation that started about 15 years ago. And the conversation started when open source was regarded as a bit risky. And the conversation was, well, what if there was a grid to allocate risk between customers and suppliers? And what if that could explain how risk existed and what mechanisms could mitigate that, who's best placed to bear it, what the supplier and the customer's arguments could be, and what type of sample wording, the model provisions, could be used. Now, this risk grid is not intended to be the exact template of what we'll do, but it's intended to show you that this is a path that has been walked before. And therefore, this is something that we can use to begin our brainstorming about how we approach model provisions. And we may even take the opportunity while we're doing our specific work around OpenChain ISO 5230 and ISO DIS 18974, that's license compliance and security assurance, respectively. We might also take the opportunity to help update adjacent material like this risk grid. Why not? Now, this risk grid, I've linked to the version that I got on their CC0 from the original authors on Google Drive. I'm aware that Google Drive is not super useful for those who are based in, for instance, China. So I've begun converting the risk grid into Markdown, and I have more generally put it as an Excel document and an open office spreadsheet in our repos as well. So yes, the Markdown version is still being populated, and of course it's not as spreadsheety as the spreadsheet, but that's not the point. I'm transferring the data and we'll organize it out later. I wanted to pause here, and if it's okay, Andrew, I'll call you to the table to let people know a little bit more about the risk grid itself, how it came to be, and perhaps what worked and what didn't, because it's been a while. It's been 15 years? At
Yeah,
least
no, it
13.
has. Yeah, exactly. I'm surprised it's written in a variety of English that I can still understand. Actually, it's so ancient. Yeah, so basically, the story was that this is back in the day when if you were negotiating contracts with suppliers, for example, and they were using open source software, then this was all sort of terribly new, and the question is, we wanted to provide something to help the purchaser in that case understand what the various issues are. There are sort of traditional things that lawyers discuss when you're talking about a supply or procurement contract or a sales contract, revolving around the intellectual property, who owns it, what the risk of sort of failure of infringement if the license if there's a problem with the license, if there's a problem with the upstream code, it's not properly licensed, etc. And this was really intended to assist lawyers who were used to the sort of traditional negotiations. So if you were negotiating with a supplier, then you would expect them to assign all of the copyright in the code that they were developing to you, and that maybe there were you talk about things like foreground and background IP and so on, but normally you'd expect the supplier to be on the hook for infringement. But that's not necessarily the case as far as open source is concerned. It can be, but it's not necessarily the case. So what we wanted to do was really deconstruct those negotiations and say, what are we actually asking for each of these particular items that we're going to be receiving, or on the flip side, what we're going to be selling, and how reasonable is it for the supplier or the purchaser to ask for these, and what arguments would you have if somebody imposes some sort of onerous term on you, and you think that it's unreasonable for you to accept that particular term. So it was a sort of educative tool. It does have, so it explains, who's best placed to manage any particular risk. And it also contains some sample wording that you could potentially use in your contract if it's appropriate. So as I say, it's pretty long in the tooth now, so it's fairly old, and it is in need of updating. But on a quick look through, I think it stands up reasonably well, and it still provides a good basis for understanding what the dynamic is between the supplier and the customer, and what issues you should be aware of in a supply contract.
And I guess another thing worth pointing out is that the document originated on the what was at that time the European Legal Network, so it had eyes on from people there. And then later it was published in the International Free and Open Source Software
Law Review
Journal.
Yeah.
Or I can't remember the name of the journal.
No, exactly, which is now called JOLTS. So it's been through some changes. So I think that URL there probably still works, but we can.
It does. It does.
Yeah. Good stuff.
I'll pull that up now so people can see it. So I mean, we're looking at a case. Andrew was being, very modest, saying it's long in the tooth. It is, but it's had a lot of eyes on. So there's there are worse places to start than by looking at something like this and thinking, well, perhaps. There we go. Introducing the risk grid. I'm just going to. Oh, we wrote the article together, Andrew, when we were babies.
We did.
I remember that. I'm putting the article into the chat now. And this is not the craziest starting point for us. So this article was 2009, at which case it was already version 8 of the risk grid. So it had been in play for a while. Mm-hmm. Right. And side note, for those of you who are aware of the bits of material around the place, yes, Andrew was involved in bringing the risk grid to life, as he was with the policy template that OpenChain uses as well. So he's been officially causing chaos across the open source ecosystem for at least 15 years. Now, this is also a document that I think many other parties have had a chance to look at over time. So I see McCoy's on the line. McCoy, I believe you're very familiar with this document. You were there as it was drafted and so on. and some newer parties in play as well. I see people dialing in who may have never heard of it. So we've got some people who may be entirely new to this field and wondering where it came from, hence we did the introduction. But just to reiterate, what we want to do is to have model provisions for the OpenChain standards, because the market is saying, what are examples of how I could include this in procurement? How could I do that? Show me some models. So we want to do that, and this document, the risk grid, is a starting point of how someone did something in creating model provisions before. What we have to do now is to brainstorm, how do we accomplish our objective? And perhaps as a secondary one, how do we do something like update the adjacent risk grid, if applicable and if still useful? We just had a legal conference here in Sweden, where I'm based right now. And at that conference, we had some discussions about the risk grid, and people put eyes on it, like Malcolm Bain, saw value in the document. So we might want to maintain that as a secondary outcome. But our primary thing is, how do we create the model provisions for us, and in what form and structure? Now, to get the conversation started, I have one suggestion. Maybe we don't use a spreadsheet. I'm not sure how we should organize it on Markdown or similar. But the biggest challenge we've had with the risk grid or similar spreadsheet material is that it's very hard to translate. And actually, we don't get as much eyes on copy editing and so on as we do in documents like Markdown. While not suggesting that we have a flat structure, such as what I'm showing on the screen, the initial translation of the risk grid into Markdown, I do suggest that we take an approach like this, which will allow us to store the material on something like GitHub, and it won't be geographically restricted like Google Documents, and it'll be easy to translate. But when it comes to how we format this information, do we format it with the same structure as the risk grid or similar structure? That door is wide open. And to be honest, I don't have a good suggestion. So I wanted to see, pausing here, if any of you have ideas about how we could usefully provide model provisions and in what structure they might be. No one wants to take that hot potato. I have a starting note. I see Andrew's about to jump in as well. My starting note is, as we create model provisions for something like including ISO 5230, perhaps we should create, for each use case, several different sample languages. So it's very clear that the models we're showing are non-prescriptive and that we can play with different approaches to including these standards in discussions with suppliers. That's just my note. Andrew, I saw you're unmuted, so over to you if you so wish.
Yes, I mean, I think a structure like this does make a lot of sense. I mean, clearly the aim is to try to disseminate this as widely as possible, and if this, is going to get greater uptake, then that's fantastic. It's also, relatively straightforward to do because we have the text there already. So it's just I say it's just a question of transcribing it. The question is who's going to do that. But we can very quickly see whether that actually works in practice or not. But I think sort of taking a step back, I mean, the risk grid is sort of mainly aimed at, and I need to have a look at it again. But it's mainly aimed at the contractual terms, between a supplier and a customer, and it talks a lot about the actual software itself. And again, I need to remind myself of this, it doesn't necessarily cover so much is the development methodology. And of course, what OpenChain is all about is providing the right context and the methodology and the production process to ensure that, I've used this analogy before. OpenChain is all about making sure that the cake factory is an excellent factory for making cakes in, and the cakes come out of it are likely to be high quality. Whereas, and I think, in a supply contract these days, what we're looking at is making sure that we are getting appropriate warranties, etc., about the quality of the cake factory, as well as the software itself. So I think that would be phase two, is to look at, if we want to focus it more specifically on OpenChain, we want to look more in terms of putting clauses in there that you know first of all, ask the question, are you OpenChain compliant? Does OpenChain, does your OpenChain program cover this particular piece of software? If you can't provide all of that information, then we break that down further into what are essentially each of the categories within OpenChain. So, do you have an open source policy? Please provide us with a copy. Do you have a training program? Do you ensure that all people participating in the development of the software that you're supplying to us have been through training routine? How do you assess this? Do you understand open source? Do you have mechanisms for providing SBOMs, for example, this sort of thing? And this is something that we have been working on in the background, and that's something that I'm sort of happy to talk about, sharing some of the materials that we've done as far as that's concerned as well.
So I'm going to jump in. Hi Shane, it's been a while since I've been at any of these. From a practical standpoint, and I spend a lot of my time negotiating the contracts, and sort of what got my attention to this was the whole notion of model clauses, because obviously that's kind of a standard practice with data protection these days, especially if we're looking at building or the way the UK is going vis-a-vis GDPR, etc. So presumably this is going to be used in conjunction with some sort of a standard quote-unquote Word document that procurement leads or contract negotiators or legal teams would be using as a schedule or an addendum to an agreement. Is that the case? And then sort of related to that is, how do we perceive this working in the context of SaaS delivered technology?
It's a very good question, and this might be oversimplifying with the power phrase, but if I recall correctly, one of the original ideas behind the risk grid was that it would allow every lawyer to create, as usual, unique and bespoke language based on what they've copy-pasted from elsewhere. And the idea was to give an armory of approaches so that legal teams would be able to take material, get context, and have some models to build on in case they didn't have their memos and notes from the past. So I think, and Andrew, correct me if I'm wrong, the risk grid's original concept was that instead of being an incredibly structured way to approach this, it would help guide people into the right direction. Give them some of the context, idea of where to put risk, and some example language, as opposed to being a structured process for locking down this stuff.
Yes, exactly. So it was never supposed to be a template contract. It provides some sample possible clauses, but ultimately it's a toolkit for whoever is assembling the contracts to be able to think about what needs to go in there as far as open source warranties and indemnities are concerned, and covering some other fields as well. But it was never intended to be a final template document.
The reason I'm asking is, and Andrew, you may not have come across this, but especially in the last 2 roles I've had, I haven't met a person on either of the legal teams that has even a sparkle in their eye as it relates to open source content in agreements, especially software agreements or SaaS. And for the most part, when I have asked for things like standard terms and conditions for the company I've been working for, and looking at incorporating this, the first thing they do is they run off to your favorite law library or what have you, and download some standard T's and C's, make a few changes to it depending on what the kind of corporate guidelines are, and then call it done. Or sometimes worse, they kind of roll over on the language that you get from a supplier, And a lot of the time it has been standard terms and conditions that everybody points to their website and go, well, go look at the website. So I it's been a while since I've gone back and looked at this, the current version of the standard for OpenChain. But depending on where you're at as an organization in the OpenChain journey, right, if you're sort of just starting, then odds are your legal team probably won't have a clue what they would need to be adding, and there'd be a lot of conversation needed with the tech teams to get there.
Absolutely,
Yeah,
Steve.
I completely agree. Yeah, and this has been a sort of problem for many years, and the law libraries are sort of slowly getting better. I'm actually working with one at the moment to try to come up with sort of slightly better precedents and a note on open source so that people understand it. But you're right, a lot of the contractual documentation is inappropriate. There are signs that it's improving, but I think the fact that this has been an open issue for so many years demonstrates that, unfortunately, it's a fairly non-trivial one. I would sort of, I don't know. I think the terms of reference for this particular group, if we say we need to provide a set of precedents that embrace open source and open chain, that's going to be a pretty monstrous job. So I think focusing on a relatively straightforward job, like updating the risk grid, so that at least what the issues are comes out into the open, and that becomes better disseminated. I think that's a good first stage on the journey. But I would sort of hesitate to try and do something which is clearly necessary, and I agree completely with what you say. But at this stage, I think it's sort of pretty ambitious.
Yeah, I mean, I think the first step we took at Cisco way back in the day was to just even start to introduce some basic requirements into the main T's and C's that anybody that we were licensing code from would declare all open source to the company.
Absolutely.
That they were using, right, as the first step. And then the risk is going to be carried one way or the other, but at least it's being disclosed. And then the other thing we would be looking at would be whether or not they've got insurance that would cover in open source violations and certain things like that. Without having actual model clauses, so to speak. Okay,
yeah,
I think
understood.
I've got a picture going on.
Yeah.
Well, Chris, you're unmuted. Go ahead.
Oh, I was just wondering what the mechanism. First, I'm brand new to this project, so apologies if people already know this. But what's the mechanism we're contemplating for ensuring that both parties to a deal are familiar with the risk matrix and the considerations that go into it? It seems like the risk matrix is a useful tool for one party when putting together their language, but I'm not. If you want to encourage adoption and you want to get more people like using these terms, it seems like we need to do something to make sure that both sides are referencing whether it's the risk matrix or some other certification or something that we're pushing here. Otherwise, it's just going to be an negotiation.
No, it's a really good point, Chris. And this is going to be a very unsatisfying answer, perhaps for both yourself and Steve. But because we want to navigate very, very cautiously around topics like US antitrust law, and we want to keep our standard very clear from prescriptive implementation choices. So, we want to provide the ability for people to get the broad strokes in place, but allow the market very much to determine how they do any specifics. So the base goal isn't to actually align people behind using this risk grid or a new series of model provisions as a standard. The base goal is to have a way for attorneys who are thinking, well, okay, I'm going to include this ISO standard for open source license compliance into my procurement discussions. I want to have some model provisions for them to noodle on it and to brainstorm. So in this sense, Chris, we wouldn't be trying to shepherd people into using these provisions as is, per se, or that they'd all agree with them. And it'd be perfectly valid for someone to look at the model provisions and say, that's terrible, I won't touch it. But the purpose would be to go from a blank sheet, which is roughly where we are today, where people might think I need to include this in procurement. How? Do I just say, you must use ISO 5230? Is that enough? And take them from that moment into having a series of options and framing for their thinking tool. And then perhaps, I mean, ultimately our goal is that whenever that happens, if one party starts using a thinking tool, maybe the other party at the table would also pick up the thinking tool. And they'd both benefit from the experience. But it would be a very soft touch item, as opposed to saying, these models provisions are actually how you should do it. It's much more a case of these model provisions show you options for doing it and the rationale for those options existing. I hope that makes sense. And it's not as it's not as good as creating a structured workflow for the market itself. But because of cautions like various antitrust requirements and so on, we err on the side of extreme caution here.
Well, I mean, everything you do at a procurement level is going to be based on the risk appetite of the organization that you're working for anyway, right? So having something that sort of articulates the risk and provides some feedback is a reasonable place to start, I think. The important thing is understanding that the people who are interpreting this have a way of interpreting the risk as it relates to how this is being provided, I think. Sorry, somebody else was about to speak and I jumped on top of them.
No worries. Steve, one thing actually, the fact that you said this first is great because I'll just piggyback off of it. I think to add to what Shane was saying, to what you were saying, one of the things that this is going to be very useful for is to educate people like the one, Steve, you mentioned, that have sort of no idea what they're doing, right? But yet have to negotiate these contracts. Because what I find is that when we're negotiating contracts for our clients, the worst situation is having a lawyer on the other side who just does not understand open source, right? Because now not only do I have to counsel my client, I have to sort of explain what we're doing to the other side. And so having something like this where you can point to it and say, look, we're not saying you have to use these terms. We're not saying you have to follow this, but these are the risks that are involved. This is what OpenChain recommends we do. Go read this, come back, and let's talk about it. I think that's going to be very helpful.
That all makes sense. My comment was more on the when you have a party who doesn't say go read to the other side, go read this, get yourself up to speed. Then you have, I was looking at the risk matrix that was shown, and when you're coming up with model provisions, you can make assumptions about who was responsible for selecting open source projects or drafting their own code and allocating risks that way. A counterparty could look at those assumptions and say, oh, well, that doesn't fit this relationship, therefore I want to ask for something different. But they don't know that unless they are prompted to go look at this risk matrix. And so I'm wondering if when we think about what a model agreement is, model terms are, there's a concept of putting both parties on notice that in order, you need to address these topics, but you also need to, by referencing you need to actually reference the model somehow in the agreement in order to be in compliance, so that both sides come into the negotiation with a similar education level.
I don't know if I I mean, I think I understand what you're saying. I think in practice, in a supply chain context, you're dealing with so many different suppliers with so many different capabilities that ultimately it's going to be the customer that would be driving the expectations around these, and would be essentially, if necessary, training the upstream suppliers to do the right thing and to provide and commit to whatever the obligations are that you decide to have. And that's going to be a side effect of the risk of that supplier poses, not just with open source, but with the overall technology or service that they're delivering, I would conjecture, if that makes sense.
Sorry to jump in, but if I got Chris correct, I think he was mentioning something like presetting a sort of an agenda that could be used in such a conversation, saying, hey, look, you should be aware of touching at least these 10, 15, 20 topics. And if you all agree that you have a solution for that, you can tick the box and then you're done, at least on that, or at least in this relation.
And I suppose adjacent to this discussion, Chris, if I also understood, this is a question of discoverability, right? So people are at a table and they're thinking, my counterparty seems to have a lot of knowledge here, or good toolkits. I don't. What do I do? And that's an interesting one. I suspect that part of that doesn't fall into what we will draft here, but it's a responsibility of the project to make discoverability of this reference material extremely fast. If a lawyer hears about OpenChain, worries about it, checks the reference library, they should immediately find, oh, there's model provisions with rationales and explanations. I'm now enabled to, even though I don't know this, I'm now enabled to read and sit down across from the counterparty and not be steamrolled.
Yeah, that's exactly what I was getting at. But the use case I'm thinking about here is when you've got parties with standard terms and standard terms plus, especially what you don't want to have happen is a party who represents that these terms are in compliance with some sort of OpenChain standard, or either these are OpenChain terms, without also informing the other side that there's optionality in them, and that it's not that the terms that are being provided aren't the only terms that are compliant. And you could actually, if you have a sophisticated party and an unsophisticated counterparty, that sophisticated counterparty could use this to try to preempt the negotiation that I think we're trying to encourage here, and that is an educated negotiation on these topics.
Which is a really good point, because we built these standards so that the implementation of the standards, the processes you put in place, are entirely variable, right? So someone shouldn't be able to steamroll you and say that the way that you train your staff has to be exactly this. That's not what the standard says. It's not what it's meant to mean. So that's a negotiation between customer and supplier and so on. So yeah, I would suggest that we try to have the simplest possible material as we get started here in terms of what's the issue, who gets it, supplier or customer, what model language is there. And then around this, at the same time, the OpenChain project tries to make sure that discoverability of this stuff is very high, so that the minute an attorney goes to the OpenChain project, they can discover that we're building out some model provisions here. And these model provisions, if other parties here agree, will include options, immediately making it clear that you're entering a negotiation, not a mandate. And the standard sets broad strokes, the rest is negotiation.
I think this is... Sorry, Shane, Karen.
I just wanted to flag one more thing based on what Joshua said a few minutes ago. He had to drop out, I think. He was just saying that we have multiple levels of model provisions at play. And he suggests that the most basic is model provisions for requiring suppliers to use the standards. Requiring or requesting, I'll just add that in. And that we'd start there as opposed to trying to allocate risk across all of the things in the risk grid plus the other stuff. And I just think Joshua might be right. Why don't we start with the smallest possible problem? How could you begin to ask a supplier what type of model language would be there to ask a supplier to adhere to, let's say, ISO 5230, or that it would be preferred if they did so. And we make a few model provisions there, and we build out piece by piece, starting at the very base level, and build a portfolio of options. Anyway, Steve, over to you.
Yeah, I was going to say that there's already an analogy to this in place, right? And that's around something like ISO 27001 from a info security standpoint,
right?
Where one organization has taken the time and energy and invested in getting itself ISO 27001 certified and has got all the internal processes and practices in place, and they're engaging with suppliers that don't. But in order to maintain their ISO 27001 certification, they have to ensure that their suppliers are at least meeting some baseline level of security so that the supply chain is intact. And I think that's kind of the concept, at least I would put that on the table here, that you would be looking for here. And that is, step one, if you're ISO, if you're compliant with the OpenChain standard, then there shouldn't be a lot for us to discuss, right? That should be good. We just make sure you maintain your certification and you provide evidence of the certification for your compliance. If the compliance is self-certified, that starts to become a different way that you would end up negotiating the T's and C's. And then you basically, to your point, I think where you were going, is you back away from that and say, well, what if they don't have it? Are they intending to get it, right? So do they have plans, or are they building up towards it, or do they not even have a clue what you're talking about? So you've got those different levels of complexity and higher levels of terms that you would need to consider adding into a contract, if that makes sense.
And there's an interesting point that Leon brought up. And by the way, hi, Leon. I was just talking with Tony earlier. It seems that today is a GTC law day. Leon brought up, which is one of the difficult things, is when the counterparty has no idea what they're doing at all. In which case, it would be the exact inverse of what Chris brought up, where someone's trying to use their knowledge as an advantage. Perhaps there's quite a few cases where you'd be trying to give the counterparty something like this model language, so they stop making stuff up randomly when they've no idea what's going on at all. Yeah, okay, sounds good. Now, let's say we get started and we do what was mentioned by Joshua, which is we create a couple of very basic model provisions for asking or requiring suppliers to adhere to the OpenChain standards. And potentially, we use exactly the same structure as the risk grid. So if the issue at play, any commentary on it, who's best placed to bear risk? In our case, it's like the supplier. The best mechanism, sample wording, supplier's argument, customer argument, and any further comment. And if that basic structure is okay, perhaps we can noodle on a few model provisions, not on this call, but offline via the mailing list, and put them on GitHub to begin populating the essentially almost compatible with existing risk grid, but slightly different. Risk grid is talking about software. We're talking about the cake factory. And to create the first few bits of that, see how it's going and see how the broader community responds to it, whether they think that approach to model provisioning provides the right context and is understandable. In Chris's well-observed case, where people need to discover something to help them hit the ground running, or in Leon's case, where you're dealing with someone who's got no idea what they're doing, so it'd be very useful if you could use this to give them one. And whether we're on the right path. Would you be amenable to taking that direction, or do you think we need a different direction as we make the model provisions?
That makes a lot of sense to me, and we've already done some work on some sort of fairly simple provisions that we could potentially use as a starting point. It doesn't have any commentary with them, but it does actually have the provisions. So I'm happy to volunteer those, and then we can work together to add the commentary as necessary if people feel that they're appropriate.
Yeah, I was going to ask you that, Andrew, if you had any sort of terms that you've already used in agreements, suitably anonymized, just to look at, because obviously that helps with sort of reverse engineering how the risk and the commentary here is managed.
Yeah, absolutely.
It will also help me jog my memory about other T's and C's that I've looked at and discussed with legal teams in the past, and maybe others as well, of course.
Now, I have a very practical question, and this goes right back to Andrew, your observation about the structural approach. So the risk grid gives us an inspiration of how this type of document can be thrown together. However, the risk grid is talking about the software, and we're going to be talking about the organizations. So it sounds like before we could, let's say, merge the two documents, we might need to start our model provision language using the same structure, but to build that out slightly separately to the existing risk grid until we're in a position to merge them and flag this optic is software, this optic is organizations, and here's model provisions with a common structural approach.
So just for my edification, maybe others, Shane, when you say focuses organization versus software, can you maybe help differentiate the two for me?
Okay. So I'm on the shared screen. Issue 1 is talking about the supplier created code creates copyright infringement. And then it's talking about the actual code, the indemnification, and so on based on that. Now, in our case, because we're going to be dealing with the ISO process standards, it would really, on the high level, as we get more granular, Steve, it'll change. But on the high level, we wouldn't be talking about the supplier level code infringing copyright. We'd be talking about, are you using the process standard in your organization? Are you using ISO 5230? Here's my language requirement, model language requirement for using this standard. And as such, it would be less of this diving straight into your copyrighted code infringement and indemnification. It would be much more talking about, are you using this standard? And then potentially, because the standard is slightly recursive, according to section XYZ of the ISO standard, you will have the compliance artifact records. I would like to have those records, etc.
Got it. So a drill down approach. So start high and then peel back the onion as you discover more. I don't see anything wrong with that. I suspect that some of these may float up to that top level area as well anyway. Yes. But I mean, you start by peeling it back in and doing, so as a software developer, you start doing the if then else, right? Or switch statement.
Exactly.
Exactly. Because I mean, the first question that you ask the supplier is, are you in respect to the software you're going to be developing for us, are you ISO 5230 compliant? And if they come back and say what you're talking about, then it's not really particularly helpful to have a clause in there saying that you're OpenChain compliant. But what you can then do is to drill down to the next level and then basically just echo the requirements of the specification and say things like, okay, do you have an open source program? Do you have an open source policy? Do you have somebody who's tasked to handle open source queries? Blah, blah, blah. So, okay, it makes the contract longer, but essentially you're asking the same questions that you would ask, to derive the answers that you would need to establish whether somebody was OpenChain compliant. So that's the way that we do it. I mean, we sort of do a due diligence process that starts with a very high level set of questions to establish if, first of all, are they compliant, and secondly, if they don't know what that means, then to extract the information that determines whether they do have a quality open source development program. And then we build that into a set of warranties that are going to be longer if they're not OpenChain compliant, because it's basically taking all the elements separately. But then even if they say they are OpenChain compliant, then we also, as you say, want some of those requirements to bubble up to the top level so that they do appear anyway explicitly.
Absolutely. And a very practical example of this, I've pulled up the ISO standard. So, you might have that basic thing. Are you OpenChain ISO 5230? You must be, or you should be, or I want you to be ISO 5230 conformant. And if yes, as per section 3.6.1.1 of the ISO standard, you should have a document affirming the program specified in blah, blah, blah. The standard meets all the requirements. And I want a copy of that document as one example model provision.
Sure. Yeah, it's exactly what we would do for ISO 27001 as well. You'd start at that level and then go, okay, you don't even know what I'm talking about. You haven't even done SOC 2. Okay, and then you go down to the next level of detail as articulated in the standard, and figure out where your minimal level of compliance would be to satisfy compliance with the standard. So.
And it seems like, this is speculative here. It's not a direction from the GM of where we should go. But it seems like if we start at the top here with the basic bits, as Joshua said, would be useful, but use the same structure as the risk grid, then as we build out, there might be an organic point where the two documents very easily merge. And we simply end up with one larger document with plenty of explanations of model provisions and options and so on for dealing with all of this different stuff. Which I guess could be the enablement document, which would help both Leon's case and Chris's case of parties that you want to know or parties that you don't want bullied, both having the ability to get the tools that they need to be in play. So the end result, fingers crossed, would be not only people have a better way to brainstorm around our standards, but people have a better way to have access to knowledge where knowledge could be useful to ensuring a good, fair negotiation between parties, which is the type of fair competition that we do love to see around open source. To get this started, my proposal is that I wander over to our GitHub and, using the same structure as the risk grid, this structure highlighted on the screen, I create a document for some of the very basic starting model provisions for us, which might start with as simple as, sample wording. We require you to have ISO 5230, and here's rationale around it. And we just get some sample provisions in place, these model provisions in place, and we take this conversation into another call in about a month where we review those first model provisions and say, is this useful for all of the parties on this call? Is this going in the right direction? And we take it from there. Are there any objections to this approach? Remember, this is a community. You can say no.
Makes sense to me.
All right. So that means my takeaway is to get working on that. We'll do this offline through the mailing list and on GitHub. And by the next call, in around a month, we'll actually have some model provisions in play for review. And perhaps, at the same time, we'll have further brainstorming around the older risk grid itself. And we might have the hints, the beginning of how we could end up with perhaps consolidated document in future. At the same time, I really want to take on Chris's comment on board that discoverability of this activity needs to be extremely high. That if an attorney now comes to the OpenChain project, they need to find this legal work group, and they need to find the risk grid, and they need to find our future ISO 5230 and ISO DIS 18974 model provisions. immediately. So they're never at a disadvantage from another party with more knowledge, at least not at a disadvantage due to our inaction. Right. That's it on my side. Does anyone else have any comments before we close? Okay. For those of you I saw in Sweden, it was fun. A few of you on the call today. For those of you I didn't see in Sweden, I'll see you elsewhere, and we will have fun too. Thank you so much for taking time on this call. I know that this was a slightly woolly call as we touched the edges and teased out the parameters here. From now on, the calls will be more focused, and product deliverable will be our goal. But we needed this to set the tone. And thank you, everyone, for making sure that tone was set nicely, easily, and relatively quickly. Have a good day.
Thanks, Shane.
Thanks, everyone.
Bye-bye.
Thanks, Shane. Bye-bye.